The morning I woke up to a bright orange final notice HOA compliance violation, stapled to my mailbox like a public execution notice, I knew two things immediately. First, someone had come onto my property again without permission, and second, the HOA president, Deborah Klein, was about to make this the worst, loudest, most legally stupid month of her life. Because Deborah didn't just knock or send emails like a normal human being, Deborah stomped, wheezed, shouted, and documented every breath. Like she was filming a reality show nobody asked for, and as I stood there barefoot in my driveway holding the notice, coffee shaking in my hand, rereading the line that said, unauthorized fencing, hostile landscaping, and intimidating deterrence, I laughed out loud so hard my neighbor Tom leaned over his hedge and asked if I'd finally lost my mind, which honestly wasn't an unreasonable question considering that for the past 6 months the HOA had been threatening me over everything from the angle of my trash can lid to the emotional tone of my front yard gnome, all because I refused to remove a narrow gravel driveway that crossed what Deborah claimed was shared HOA visual space, a phrase she invented during a board meeting while pounding the folding table with a donut-stained fist and insisting the driveway made her feel unsafe as a pedestrian. Even though she never walked anywhere and arrived at every meeting in a mobility scooter, she once rammed into my fence out of spite. See, the truth, what Deborah hated more than the driveway, more than the gnome, more than me, was that I had records, old boring county records, the kind printed in faded ink and stored in dusty drawers, showing that my property line extended 3 feet farther than the HOA map claimed, which meant the strip of land she kept marching across to inspect wasn't community property at all. And when I calmly explained this with copies, stamps, and a surveyor's signature, she smiled the way people do. Right before calling the cops for no reason and said, well, we'll let the courts decide, which is HOA language for we will harass you until you fold, and I didn't fold, not when she sent daily violation emails titled friendly reminder written entirely in capital letters, not when she photographed my backyard through the slats of my fence while loudly narrating into her phone about possible hostile intent. And not when she personally showed up with 2 board members, both of whom looked like they regretted every life choice that brought them there, to demand I remove my menacing gravel, at which point she stepped onto my land again, planted both feet, hands on hips, chest heaving like a furious bellows, and said, you can't stop me from standing here, and something in my brain finally snapped into a calm, beautiful clarity because I remembered a conversation I'd had years earlier with a retired electrician buddy who once said jokingly, you know, electric fences are perfectly legal if you do them right, and that night, after reading state statutes, county ordinances, and 3 separate HOA bylaws that never once mentioned electrified fencing because apparently nobody expected someone to push things this far, I decided I was done playing defense, so I installed a low-voltage, clearly marked, code-compliant electric fence exactly on my surveyed property line, complete with warning signs every 10 feet, professionally grounded, inspected, documented, and approved by the county. And the next morning Deborah arrived like clockwork, clipboard tucked under her arm, breathing hard before she even reached my driveway, and without reading a single sign she marched straight onto my property, took 1 step, screamed like a tea kettle being murdered, and fell backward onto the grass yelling, assault, while I stood on my porch holding my phone, recording, calmly announcing the date, time, and that she had ignored multiple warnings, which of course only escalated things because within an hour the HOA's lawyer emailed me threatening fines, liens, and immediate legal action, followed by Deborah herself leaving me a voicemail that consisted mostly of wheezing rage and the phrase, you electrified the neighborhood. And that's when the real war began, because suddenly I was receiving certified letters accusing me of booby traps, hostile deterrence, and intentional infliction of emotional distress, while I responded with nothing but statutes, inspection reports, and timestamps, and every single HOA meeting turned into a circus where Deborah would dramatically recount the incident with exaggerated hand gestures, claiming she'd been launched several feet through the air, while the board members stared at the floor and I sat silently in the back, occasionally sliding a printed law across the table like a poker chip. And the funniest part, truly, the part that made me realize how badly they were miscalculating, was when the HOA filed for an emergency injunction to have my fence removed, because in doing so they dragged everything into court, including my survey, their inaccurate map, their repeated trespassing, and Deborah's own emails admitting she stood on the disputed strip to prove a point, which is not something you want read aloud by a judge with glasses halfway down his nose and zero patience for suburban theatrics. And as the court date approached, Deborah doubled down, telling neighbors I was dangerous, that pets were at risk, that children might be launched, even though the fence barely produced more than a sharp zap and was less powerful than a cattle fence you could buy at a farm store, but fear works wonders in a cul-de-sac, and for a brief moment I became the villain in whispered conversations, until discovery started and the HOA had to hand over internal emails, including one from Deborah saying, "If we make this expensive enough, he'll cave," and another where she suggested testing the fence again to document severity, which the judge later described as remarkably unwise. And by the time we walked into that courtroom for Section 1 of what would become a spectacular self-destruction, Deborah was confident, dressed in a blazer 2 sizes too small, clutching her binder like a weapon, unaware that every threat, every trespass, every dramatic collapse had been documented, because the electric fence wasn't the trap. They were, and they had walked into it screaming. By the time Section 2 began, the HOA had convinced itself this was no longer about a fence but about authority, which is HOA code for we are losing and don't know how to stop. And Deborah Klein walked into the courthouse that morning like a woman heading into battle, armed with confidence, perfume, and absolutely no understanding of how discovery works, because while I arrived early quietly, carrying a slim folder and a thermos, Deborah arrived late, loud, and already sweating through her blazer, loudly informing anyone within earshot that she had been electrocuted on her own street, which earned her exactly zero sympathy from the bailiff who told her to sit down and stop blocking the aisle. And when court finally started, the judge, an older man with the expression of someone who had seen every possible variation of human nonsense, asked the HOA's attorney to explain why an emergency injunction was necessary, and that's when things started unraveling fast because the attorney launched into a dramatic speech about dangerous installations and booby traps, only for the judge to interrupt and ask very calmly, "Is the fence compliant with county code?" To which the attorney hesitated, glanced back at Deborah and said, "We believe it is hostile in nature," which is not an answer to that question. And I could actually see the moment the judge's patience began to evaporate like spilled coffee on hot asphalt, especially when I was invited to speak and simply handed up my inspection certificate, survey, permit, warning sign photos, and a highlighted copy of the state statute explicitly allowing low-voltage electric fencing on private property. And while the judge flipped through it, Deborah began whispering furiously to her lawyer, gesturing wildly at me, her face red, chin quivering, until the judge looked up and said, "Ma'am, if you interrupt again you'll be removed," which somehow only made her louder later because once testimony began, Deborah took the stand and immediately tried to turn it into a one-woman show, describing herself as a community servant, claiming she'd been thrown backward violently, and insisting she feared for her life, at which point my attorney calmly asked her to describe how she came into contact with the fence, and Deborah, without realizing the trap, puffed out her chest and declared, "I walked where I always walk," which led to the simplest, deadliest follow-up question imaginable. "And where is that, exactly?" According to the survey. And when Deborah snapped that the survey was fake, the judge asked her if she was a licensed surveyor, to which she responded, "I've lived there 12 years, a statement that hung in the courtroom like a bad smell, because residency does not grant magical land measuring powers, and things went from bad to catastrophic when my attorney introduced video. My calm porch recording of Deborah ignoring warning signs and stepping onto the property line while narrating into her phone about testing compliance, followed immediately by her scream and theatrical collapse, which played on the courtroom monitor in crystal clear resolution, and I swear you could hear people in the gallery suck in air all at once, because it didn't look like an ambush, it looked like exactly what it was. A woman trespassing, ignoring warnings and suffering a predictable consequence, and Deborah tried to interrupt, shouting that the video was edited, until the judge reminded her she was under oath, and from there the HOA's position disintegrated piece by piece, because discovery emails were introduced showing Deborah instructing board members to document violations aggressively, her suggestion to stand our ground literally, and the infamous line about making it expensive enough to force compliance, which the judge read aloud slowly twice, while Deborah's lawyer stared at the table like it might open up and swallow him, and suddenly the narrative shifted from dangerous homeowner to overreaching HOA, especially when it became clear this wasn't the first time Deborah had trespassed, harassed, or escalated disputes, as two neighbors testified, reluctantly but truthfully, that Deborah had previously walked into backyards, moved property markers, and once tried to measure a fence using her shoe, because it was faster. And the judge's questions became sharper, more pointed, asking why the HOA map didn't match county records, why warnings were ignored, and why an HOA president thought it appropriate to physically test a fence instead of reading posted signs. And Deborah, now flustered and sweating, snapped that she was protecting the community, which is when the judge leaned back and said, "From what, exactly?" And she didn't have an answer, not a real one, just vague statements about aesthetics, feelings, and the type of precedent this sets. which was ironic because the precedent being set in that courtroom was that HOAs cannot invent authority where none exists, and by the end of the hearing the judge denied the emergency injunction outright, stating on the record that the fence was lawful, the property line was clear, and the HOA's actions bordered on harassment, a word that hit Deborah like a slap because her head snapped up and she opened her mouth as if to protest, only to be silenced by a raised judicial eyebrow. And while that alone would have been enough to end things, it didn't, because outside the courtroom Deborah couldn't stop herself, cornering reporters from a local community blog and loudly declaring she would take this all the way, that she had medical trauma, and that I was dangerous, which she then repeated in an HOA-wide email blast sent that same afternoon accusing me of endangering residents, an email that, unbeknownst to her, would become Exhibit A in the next phase of her downfall, because instead of backing off after losing in court, the HOA escalated again, issuing fines for hostile installations, threatening liens, and demanding the fence be powered off during daylight hours for safety. And that's when I filed my response, not emotional, not loud, just methodical, requesting a hearing on selective enforcement, harassment, and defamation, attaching the judge's own words from the injunction denial, Deborah's post-hearing email blast, and a timeline of repeated trespasses. And when that filing hit the HOA's lawyer's inbox, the tone changed overnight because suddenly the question wasn't whether my fence would be removed but whether the HOA itself was about to be put on trial, and Deborah, still convinced volume equaled power, called an emergency HOA meeting where she ranted for 40 straight minutes about standing strong, proposed a special assessment to fund the fight, and was met with silence, then murmurs, then outright resistance as homeowners began asking how much this would cost and why their dues were being used to pursue a case they'd already lost. Once, and as the room turned on her, Deborah did what she always did when control slipped. She blamed me, pointing, shouting, accusing me of manipulation, unaware that the real damage wasn't being done by the fence or the court but by her own refusal to stop digging, because Section 2 ended not with a bang but with a quiet, deadly realization spreading through the neighborhood. The HOA president wasn't protecting them anymore. She was the liability. Section 3 began with panic, not mine, but the HOA's, the kind of slow, spreading panic that seeps into emails at midnight and shows up as urgent, subject lines sent to everyone except the people who know what they're doing, and I knew at the moment Deborah Klein, who had once strutted through meetings like a general, started sending rambling messages full of bold text, underlines, and grammar that collapsed under its own weight, insisting the board stand united, while quietly canceling the next open meeting due to scheduling conflicts, which was HOA speak for we're afraid to face the homeowners, because the moment residents realized their dues were about to be weaponized to fund Deborah's personal vendetta, the tone shifted from polite compliance to open skepticism, and suddenly neighbors who had avoided eye contact for years were stopping by my driveway asking careful questions about surveys, statutes, and whether the electric fence could, in fact, launch a human being several feet, which I explained patiently while pointing to the clearly labeled voltage rating printed right on the control box. And when word spread that I had filed for a harassment and selective enforcement hearing, the HOA's legal posture didn't just weaken, it began actively eating itself, because their lawyer, now painfully aware that discovery had already hurt them once, advised de-escalation, only to be overruled by Deborah in an email she accidentally CC'd to half the neighborhood, where she declared, backing down now would make us look weak, a sentence that instantly became legendary, printed, forwarded, and read aloud in driveways like a cautionary proverb. And the true comedy of the situation was that Deborah still thought the electric fence was the problem, so she ordered a compliance walkthrough, which is how 3 board members, none of whom wanted to be there, found themselves standing 10 feet from my property line while Deborah gestured angrily from a safe distance, instructing them to observe without touching, as if she were directing a bomb squad, and when one of them asked if the fence was actually dangerous, Deborah snapped, "It attacked me," which was said with such conviction that even the bird seemed confused. And this might have continued indefinitely if not for the next court hearing, where the judge reviewed my harassment filing and immediately honed in on the post-injunction email blast, reading Deborah's words aloud again this time asking the HOA's attorney why his client had continued to make public accusations after being warned in open court, and the attorney, now visibly exhausted, tried to argue that it was internal communication, only for the judge to ask how many people constituted internal, because his copy showed over 100 recipients, at which point Deborah attempted to speak, was told not to, spoke anyway, and was threatened with contempt, which finally shut her up for nearly 3 full minutes, a personal record, and the judge didn't yell or dramatize, he didn't need to, He simply laid out in clear, measured language that the HOA had overstepped, trespassed, ignored evidence, escalated after warnings, and now appeared to be retaliating against a homeowner for asserting documented property rights. And when he said the words pattern of harassment, the courtroom went dead quiet, because that phrase has consequences, and those consequences arrived swiftly in the form of a temporary order. Barring the HOA and its representatives from entering my property, communicating with me outside legal channels, or issuing further fines related to the fence until final resolution, which effectively gagged Deborah, and the fallout back in the neighborhood was immediate and hilarious, because the same woman who once marched freely across lawns now had to cross the street to avoid accidentally making eye contact with my driveway, and while she fumed silently, the board fractured openly, one member resigning for personal reasons, another openly questioning expenditures, and a third asking, on record, whether they should consider removing Deborah as president to mitigate risk, a phrase that landed like a thunderclap, and Deborah, sensing the tide turning, made the worst move yet. She doubled down publicly, posting on the HOA forum that she was being targeted for her size, her voice, and her leadership, despite no one mentioning any of those things, which prompted half the neighborhood to finally speak up, pointing out that the issue was land surveys, trespassing, and misuse of funds, not feelings, and as the thread exploded into chaos, screenshots were taken, saved, and forwarded straight to my attorney, who smiled in a way that suggested this was going extremely well, because every unhinged post, every accusation, every refusal to stop talking was digging the hole deeper, and by the time Section 3 reached its peak, the HOA wasn't fighting me anymore, it was fighting itself, trapped between a president who refused to accept reality and a membership that had begun to understand the terrifying power of documentation. And as rumors spread that a recall vote was being discussed, Deborah's authority evaporated in real time, her voice still loud but increasingly ignored, and I didn't need to do anything at all except wait, maintain the fence, and respond through proper channels, because the war she started with threats had transformed into something far worse for her: accountability. Section 4 started the day Deborah Klein realized, far too late, that the electric fence hadn't shocked her nearly as hard as reality was about to, because when the final hearing arrived, the courtroom wasn't packed with drama so much as paperwork, the kind that kills egos quietly, and Deborah waddled in carrying 3 binders stuffed with feelings while I brought one thin folder full of facts, and the judge noticed immediately, because judges always do, and from the first minute the tone was different, less spectacle and more consequence, as the HOA's attorney opened by actually conceding, that the fence itself was lawful, which caused Deborah's head to snap toward him like she'd been betrayed by gravity, and while she tried to whisper-shout objections, the judge raised a hand and said, "No ma'am, you've said enough in this case," which felt like the emotional equivalent of turning off a leaf blower, and from there the collapse was orderly but brutal, because the court walked through everything step by step: the inaccurate HOA map versus the county survey, the documented trespasses, the violation notices issued after the injunction denial, the defamatory email blast, the forum posts, and finally the financials, which showed HOA funds being used almost exclusively to pursue me while other community issues, roof repairs, drainage complaints, broken lighting, sat ignored, and when homeowners testified, not angrily but tiredly, explaining how they'd been pressured to stand united, and shamed for questioning costs. The judge didn't need theatrics to see the pattern, and Deborah, red-faced and breathing hard, finally took the stand again despite her lawyer's clear desire to fake a medical emergency and flee, and when asked why she continued enforcement after being warned, she said the quiet part out loud, declaring she couldn't allow one homeowner to win, which drew a visible reaction from the judge, who leaned forward and said, "This court is not a contest." And with that sentence the case ended in everything but paperwork, because the ruling came swiftly: permanent dismissal of all HOA claims regarding the fence, an order barring the HOA from enforcing anything on the disputed strip, reimbursement of my legal fees, and, this was the part that made the room buzz, a directive that the HOA review its governance due to misuse of authority, which is judicial for you people need supervision, and Deborah didn't scream this time, she just sat there, stunned, binder slipping from her lap as the weight of it all finally exceeded the weight of her confidence. And outside the courthouse neighbors didn't celebrate loudly, they just nodded, relieved, because the war was over, and within weeks a recall vote removed Deborah from the presidency by a landslide, her replacement quietly restoring normalcy, issuing an apology letter and refunding part of the special assessment, while the electric fence remained right where it was, humming gently, legally, peacefully, a silent reminder that sometimes the funniest victories aren't loud at all, They're documented, signed, and enforced by a judge who has absolutely had enough. Section 5 didn't feel like an ending so much as the long, awkward silence after a very public meltdown, the kind where everyone pretends nothing happened while absolutely remembering everything, because once Deborah was removed from the HOA presidency, the neighborhood entered a strange recovery phase where people rediscovered what it felt like to live without weekly violation threats. And the first sign of real change came when the new interim board president, a soft-spoken retired accountant who looked permanently apologetic, walked up my driveway, stopped well short of the electric fence like it might leap at him, and politely asked if we could talk as neighbors, which was the first time anyone from the HOA had used that word in years, and the conversation itself was almost comically normal, consisting mostly of him acknowledging mistakes, explaining that the association's attorney had advised a full reset, and asking, very carefully, if I would consider attending a meeting to explain the property line issue to calm lingering fears, which I agreed to because victory tastes better when it's quiet and complete, and that meeting was a masterpiece of restrained embarrassment as homeowners sat folding chairs in a half-circle while a projector displayed my county survey, and I explained, slowly, calmly, like addressing a classroom, that land does not change shape based on feelings, that warning signs matter, and that electric fences don't attack people unless those people ignore signs and step where they shouldn't, which earned a ripple of nervous laughter and several pointed glances toward the empty chair Deborah used to occupy, and when questions came they weren't hostile but curious, practical, even sheepish, including one man asking if the fence would hurt a raccoon and another woman asking if HOA leadership could really be personally liable for harassment, to which the attorney present cleared his throat and said, in certain circumstances, yes. A sentence that landed like a moral lesson nobody had wanted but everyone needed, and life began to normalize after that, though normalization in a neighborhood like ours still meant occasional absurdity, like Deborah's loyalists, now suddenly very quiet, walking extra wide arcs around my fence, or the day a moving truck showed up at Deborah's house and half the block pretended not to notice while absolutely noticing, because rumors spread fast when someone who once ruled by clipboard and volumes suddenly retreated under the weight of her own emails, and I never saw her confront anyone again, not loudly at least, though I did hear she tried to start a private Facebook group titled, Concerned Residents for Safe Neighborhoods, that lasted exactly 12 hours before devolving into arguments about trash pickup. And meanwhile the HOA quietly revised its bylaws, added language about due process, trespassing, and enforcement limits, and implemented a rule requiring all inspections be scheduled and accompanied, a rule that would have prevented this entire saga if it had existed earlier, and the funniest part, the truly satisfying slow-burn punchline, was that the electric fence became boring, invisible, even a non-issue, humming along without drama because once authorities stopped testing it, it stopped being exciting, and neighbors stopped fearing it once they realized it wasn't out to get them, and sometimes I'd catch myself standing in my yard, coffee in hand, watching the sun hit the warning signs just right, thinking about how close I'd come to backing down early, to removing the gravel, to apologizing for something I didn't do just to keep the peace, and how that instinct, to placate, to shrink, was exactly what people like Deborah relied on. And when I ran into the former HOA lawyer months later at a coffee shop and he nodded knowingly and said, that case is still talked about, I understood why, because it wasn't really about a fence or even about one loud, overconfident HOA president, it was about what happens when entitlement meets documentation, when bluster meets statutes, when someone finally says no and means it, and in the end the neighborhood didn't become perfect, HOAs never do, but it became quieter, fairer, less afraid, and the electric fence stood there like a ridiculous, legal monument to the idea that sometimes the most effective boundary isn't anger or shouting or even revenge, it's knowing exactly where your line is and refusing to let anyone cross it again. Section 6 unfolded months later, long after the court files were stamped closed and the electric fence had become just another background hum of suburban life, when the HOA attempted what it optimistically labeled a community healing phase, which in practice meant pretending nothing catastrophic had happened while carefully stepping around the crater Deborah left behind. And this was when I learned that consequences don't end when the gavel drops. They echo, sometimes comically, because the association's insurance carrier launched an internal audit after seeing the reimbursement order, and suddenly every decision Deborah had ever made was being examined by people who spoke only in bullet points and liability terms, which caused a quiet panic that made the earlier drama look amateur, as board members scrambled to explain why inspection photos existed of people standing inside private yards, why emails were sent at 2 a.m. threatening fines without votes, and why one president seemed to have treated enforcement like a personal vendetta rather than a fiduciary duty, And while all this was happening, I received a very carefully worded letter from the HOA's attorney offering what he called a goodwill settlement for mutual closure, which translated to a modest check and a promise not to sue each other again, and I signed it happily because closure is underrated, especially when it's paid for. And the truly funny part was that the electric fence, once described as a neighborhood menace, became a point of fascination, with neighbors asking practical questions, joking about installing one to keep solicitors out, and one guy asking if it could be tuned to repel his brother-in-law. And meanwhile Deborah, now fully out of power, attempted a brief redemption tour by showing up at a community picnic where she tried to explain her side, only to be met with polite nods and swift exits as people suddenly remembered urgent tasks elsewhere, because nothing deflates a tyrant faster than indifference. And the last I heard, she had moved 2 streets over into a non-HOA area where, according to rumor, she once tried to complain to the city about a neighbor's hedge and was told to file a request like everyone else, which felt like poetic justice wrapped in municipal paperwork. And as summer rolled into fall, the neighborhood settled into something healthier, not perfect, not utopian, but quieter and more respectful, where notices were sent calmly, property lines were honored, and nobody marched uninvited into anyone's yard anymore. And sometimes late in the evening I'd walk the boundary, read the warning signs glowing softly in the dusk, and laugh, not loudly, just a quiet, satisfied laugh, at how something so small, so lawful, and so well documented had toppled a reign built entirely on volume and entitlement, because in the end the electric fence didn't divide the neighborhood at all. It drew a line that finally taught everyone, especially the loudest among us, the difference between authority and ownership, and that lesson, unlike the fence, didn't need electricity to stick.